Hi, my name is Petra and I'm a quantity surveying student at Limerick Institute of Technology. Today I will speak to you about the Arbitration Act 2010, in which I have prepared a PowerPoint on. I am part of Micheal Mooring's Construction Law module and my K number is K00229585. The Arbitration Act 2010. The Arbitration Act 2010, the introduction. Throughout this PowerPoint I will explain to you the full title of legalisation, the main purpose of legalisation, an analysis on how it may affect people working within our construction industry, a list of resources from which I got my information from, and finally, recommended future readings will be proposed towards the end. Also towards the end of this PowerPoint, I will give a brief reflection on how I felt the Arbitration Act benefited me from learning from it, and also, if I was an employee in future years, how I feel I would benefit or how I would use the Arbitration Act throughout my workforce as a quantity surveyor. Firstly, we will reflect on the scope of the history of the Arbitration Act 2010. The Arbitration Act 2010 has an ancient procedure in Ireland which may be treated back to the British laws. The introduction of common law in Ireland produced the first statute in 1698, following on Irish independence. The Arbitration Act 1954 was largely based on the English Arbitration Act 1950. The Act was passed and provided by the arbitration structure in this jurisdiction for the next 60 years. This Act was amended by the subsequent Act in 1980 in relation to the Arbitration Act 1999 and the International Commercial Act. From my readings of the history of the arbitration, I feel as though I have benefited and learned from the scope of what was happening over the past number of years, which then led to the 8th of July 2010, where the Arbitration Act 2010 was commenced, which repealed previous arbitration and adopted the uncritical model law into the Irish legal system. The purpose of the Arbitration Act within the construction industry. The purpose of the Arbitration and Conciliation Act 1996, otherwise known as the Act, is to provide quick redressal to commercial disputes by private arbitration. A quick decision of any commercial disputes is necessary for a smooth functioning of a business and industry. Internationally, it is accepted that normally commercial disputes should be solved through arbitration and not through normal judicial systems within the construction industry. The judging and understanding of a dispute between people or groups by someone who is not involved. A mini trial held in attempt to avoid a court trial and conducted by a person or a panel of people who are not judges. The arbitration may be agreed to by the parties. It may be required by a provision in a contract for settling disputes. To avoid clogged court calendars, the parties often agree to have the matter determined by a panel, such as one provided by the American Arbitration Association. It may be carried out by a retired judge, a respected lawyer, or someone that provided these services. Within the construction industry, principles of arbitration involve the appointment of a third party as a tribunal to determine a dispute between two parties to an agreement or contract. The decision of the tribunal must be final and binding on both behalves. How it positively affects people in the construction industry. It is private. There is no public record of any proceedings, although it is not necessarily confidential. Speed and flexible. Although this depends very much on the manner which the arbitrator conducts the arbitration, avoiding overcrowded work calendars and hearings. The parties can agree on the arbitrator with relevant expertise in the matter. The arbitrator's award can be enforced as a judgment of the court. Private parties sometimes agree to keep the proceedings and terms of the final decisions confidential, which gives a sense of security throughout the arbitration. It might cause some embarrassment or reveal private information such as the company's client list. How it negatively affects people in the construction industry. The parties must bear the costs of both the arbitrator and the venue. Sometimes arbitration simply mimics court processes, and so you do not get the advantage of informality and speed. Limited powers of compulsion or sanction if one party fails to comply with the directions of the arbitrator, which can significantly slow down the process. The arbitrator has no power to make interim measures such as preservation of property. Speak in your mind. If you find an arbitration clause objectionable, be sure to make your feelings known to the company and management. It is sometimes possible to negotiate the provisions away if the company wants your business badly enough. Negotiations throughout the arbitration process. The arbitration has no process to make interim measures such as preservation of property. In this case, the contractor must ensure to speak their mind, and if they find an arbitration clause objectionable, they must be sure to make their feelings known to the company's management, as already stated. It is sometimes possible to negotiate the provisions away if the company wants your business badly enough. Competence from both sides, from the arbitration and the construction worker, is extremely important to ensure the arbitration process is constructed properly. Ensure all rules and regulations are properly met throughout the arbitration process to promote equality within the workforce. Proposals for the future with Ireland and Arbitration Acts. Expectations for the forthcoming future is that there will be an increase in arbitrations in the coming years now, and the 2010 Act is in force. The policy behind the 2010 Act is to severely restrict the grounds for the court interference in the arbitral process. It is considered that this will make Ireland a significantly more attractive venue for the international commercial arbitration. As a member state of the European Union with a common law system which recognises international laws is a huge benefit towards the Irish judicial system. With national implementing measures, a specified judge and a pro-arbitration culture, Ireland is the ideal location for arbitration since the 2010 Act was implemented. I have listed 5 future readings in which I have come across. Thomas Crowley, 1994, The Arbitration Advocacy, Hawaii Bar Journal, September. Helen Culliner, 1994, Practical Guidelines for Lawyers Representing Clients in Arbitration Proceedings Today, Dispute Resolution Journal, September. James Day and Leslie Britton, 1994, Arbitration by the American Arbitration Association, North Dakota Law Review. Hayley Nolan and Jacqueline M., 2001, Alternative Dispute Resolution in a Nutshell, 2nd edition, St. Paul, Minion, West Wadsworth. Stephen J. Ware, 2001, Alternative Disputes Resolutions, St. Paul, Minions, West Wadsworth. I've come to the end of my PowerPoint here today, and now I would like to briefly reflect on how I feel the Arbitration Act would benefit me in my future years to come. As I am studying QS, and I feel as though Arbitration 2010 will benefit me as an employer in the forthcoming years. I have learned, from my understanding, I have learned about the Arbitration Act, the fairness, the less expenditure, time-wise, and the privacy are all appealing factors. Although sometimes with the positives, you will always have your negatives. From my PowerPoint here today, we have learned that the negatives to arise are the cost of the venue and the cost of the arbitrator, also the very limited powers in which may benefit you. Nevertheless, Ireland, the more attractive venue for international commercial arbitrations, and also a member of the European Union with the common law system, which recognises international laws, which is a huge benefit to the Irish legal system and cannot be denied throughout years to come. I feel as though this will benefit me as a quantity surveyor in years to come if a dispute does arise. Thanks a million for watching, and I really hope you enjoyed my PowerPoint. Kate Drennan, Quantity Surveying 2, Limerick Institute of Technology, Lecturer Micheal Mooring, Module Construction Law.